Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're talking about truck accidents and all of the potential defendants that you could sue and all of the potential insurance policies out there that may be applicable. And one of the ways that a personal injury plaintiff can recover more compensation is by something known as a broker or shipper liability case. And what does that mean? Well, one of the ways that you can obtain more insurance, for example, if someone is injured by a tractor trailer, but it's just a little mom and pop shop, small tractor trailer like owner operator, and there isn't enough insurance and you have massive serious injuries like a wrongful death or a permanent brain injury or something else that's life-changing, what you may want to do as an attorney is to look into this idea of suing the shipper and suing the broker. So I want to start out this video by talking about some definitions. What does it really mean? So one of the ways that you can add additional defendants and make more money is by suing the broker. Now, the broker, by definition, is not the motor carrier. The motor carrier is the actual tractor, right? That's the actual truck, the motor carrier. And the broker is also not the employee or agent of the motor carrier, but the broker is somebody who, just as the name implies, brokers or arranges for transportation. And they're licensed only as a broker. They're not licensed as a motor carrier or as anything else, right? So that's the broker. Now, the definition of a shipper is a person whose goods are being moved or transported. That's the shipper, right? The person who needs to get their stuff moved, whatever the stuff may be, right? Pallets, could be Amazon, it could be like anything, right? It could be food, it could be any kind of goods. So that's the shipper. And then there's something known as LTL, and what that refers to is less than a truckload shipment. And so what they often do is if you have less than a truckload LTL, you'll combine them in order to fill the trailer. So those are just some brief definitions. And I was watching a webinar where an attorney explained the broker-shipper liability. And basically they said the same thing, that when there's not enough insurance, that's when you want to look into broker-shipper. And they gave an example of a case where a truck driver was driving and he must have fallen asleep and he crashed into many different cars and 5 people were actually killed in this crash, and the district attorney brought criminal charges against the trucker, and they found out that he forged his medical certificate, that he didn't even have a proper medical certificate. It was forged, and this crash happened when he was going 70 miles an hour. And he never applied the brakes, so they think he fell asleep. And the ECM, the black box of his truck, confirmed that his speed was really 70 miles an hour. And so they brought this case, and they also looked into this broker-shipper liability because there wasn't enough coverage for all of the people. So one of the issues they discussed was the venue. And so the venue for the broker-shipper lawsuit can be different from the venue of the truck crash. And basically the law on broker-shipper comes down to an agent or a principal versus agent relationship. And what it really comes down to is that the principal is responsible for the conduct of its agent. But the principal is not responsible necessarily for the conduct of an independent contractor. So a lot of this turns on the issue of control. Who controls the method and manner of the entire process? Because if it is an independent contractor, if they're truly independent and they make all the decisions, then there could be no liability. But if there is control over the method and the means and the manner of the work and the entire shipment and the transportation, then the principal can be liable. And there are a lot of interplays. There's broker-shipper, there's broker-driver, and there's also shipper-driver. And it really turns on the principal's right to control the manner of the work. And then another type of claim you can have is a negligent hiring claim, where the company you hire to perform the work may not be reasonably safe. And then if you knew that, or if you should have known that, you could be liable for that. So that's basically the broker shipper. And they also talk about a bill of lading, and that's an important document to get in discovery, because that'll talk about the type, the quantity, and the destination of the goods. And it's really a title document. So it gives the motor carrier title to the goods so they could legally haul and transport them. So the bill of lading is something that's very crucial. And sometimes in the bill of lading, you'll see the truck line on the bill of lading will not be the motor carrier, but it'll actually be the broker. And so that could be one of the factors that the court considers in determining whether the broker was liable, because if it's really the broker, then you know, it's not a proper separation. So basically what the courts have been saying, and you know, he went through a few in the webinar, they went through a few decisions. One of the decisions is known as the L.B. Foster Company case. And what the decisions basically say is that one who employs a contractor has to investigate the reputation, and especially if the type of work is dangerous, like driving a truck or transporting, you know, interstate commerce, if it's something that's dangerous, they have to find out their actual competence. So not just their reputation or their experience, but also their actual competence. So there is a duty, if you're employing a contractor, to find out that. And then brokers and shippers must use reasonable care when selecting motor carriers. And if they don't use reasonable care, then the brokers and shippers can be liable. And that's known as the Schramm case, and it was against C.H. Robinson. And there was another case called Spurl, also against C.H. Robinson. So those were like the three cases that this particular attorney mentioned. And he said also in discovery, a lawyer that's handling one of these cases would want to get the contract. And there are actually three types of contracts that usually exist. There's a contract between the driver and the motor carrier. There's a contract between the motor carrier and the broker. And there's also a contract between the broker and the shipper. So you want to get all of those contracts, because the contracts will spell out the obligations and the responsibilities of each party. And they'll say sometimes whether one party is the agent of another. And remember, if they are an agent, then you have liability. And so in depositions, like for example, in this case that we were talking about with the involuntary manslaughter, with the criminal case where the truck driver just fell asleep and crashed into all these cars and killed 5 people, in the deposition, they found out that the broker works almost exclusively with this one shipper. So that kind of showed that, hey, wait a minute, you're not really a broker where you're brokering different loads for different companies. You're a broker for this one shipper. 98, 99% of all their work was this one company. And so the shipper was required, their driver to do certain things. Like they required their driver to count the cases, to unload, to sort the product. So now the shipper has an element of control because they're requiring their driver to do all this. So control is really key. And, you know, and they actually even mentioned a few different elements of control that they find as being, you know, most important, the most important elements of control. And I can go through those quickly. Basically, here they are. Okay, these are the most important elements of control. So these are 10 signs, or the top 10 signs that you have a broker shipper case. Number one, like we talked about, you don't have enough insurance. The motor carrier is underinsured. Number two, the owner operator or a mom and pop trucking company. So it's a small, you know, company that doesn't have enough insurance. Number three, that there are safety violations, blatant safety violations. Number four, that there were fines or penalties, and you had this fine or penalty language in the contract or in the bill of lading. And remember, we mentioned 3 different contracts, so you want to get all those contracts. Number five, that there's agency language in the contracts. And agency language basically means that one person is the principal and then others are agents of the principal. So there's certain agency language that a lawyer could look out for. Number six, The right to control language is in the contracts and the bill of lading. So that's really important. It really turns on control. Another element where everything turns on control is whether someone is an employee or an independent contractor. And you get that a lot in premises liability cases, other types of cases. And we've done a lot of research on that and a lot of appellate division work on that. So this sounds very, very similar, because in those cases, it all turns on who controls the means and the manner and the method of the work, whether you are an independent contractor or whether you're an employee. And it's very similar here. Number 7, that the shipper or broker imposes a deadline for delivery, because if they impose the deadline for delivery, then they have control, right? Number 8, the broker is working exclusively for the shipper. Like we just mentioned, in this case, it happened, and that's one of the factors. Number 9, that there's a special instruction in the bill of lading or the load confirmation sheet, known as the LCS, a special instruction that tells you what has to happen, right? Because that also shows that you have to have this, and that's an element of control. And then number 10, that the broker is identifying itself as or acting as a motor carrier. Because if the broker is saying it's a motor carrier, holding itself out to be a motor carrier, or acting as a motor carrier, like for example, in that case from the webinar, the broker was actually listed as the motor carrier on the bill of lading. So that's number 10, if the broker is identifying itself, holding itself out, or acting as the motor carrier. So I hope this was helpful. What I would say is, if you think you have a potential case that involves a truck accident with a serious injury, I would speak to your attorney, and I would make sure your attorney is familiar with broker and shipper liability. And if you have a case where you need a consultation, just text me, 347-566-9595. I've been doing consultations, and I'm actually going to do a few more right after this video. I've been doing them all week. And, you know, if we have a case here in New York, we always look into broker and shipper liability. And if I partner with a firm, whether it's in wherever it is, in California, in Ohio, Texas, we had some cases in Illinois this week that we were working on with people that called, I would always look into this broker, shipper, or other potential defendants, right? You always want to make sure that you go for the maximum, because our goal is helping serious injury victims and families. We want to get the maximum possible result we can get for you, for our clients. Okay, all the best. Please like and subscribe to our channel. Let us know what questions you have. Like I said, if you have a need for a private consultation, it's free and it's confidential. And you could do that by texting me, 347-566-9595. But otherwise, just like and subscribe to our channel. We have some cool merch, justice and passion, and on our store, and we're going to do some more lives where you could join us live, ask us questions, or we're just going to read your comments and answer your questions live. Okay, all the best. Have a great day. We'll talk to you very soon.